great pleasure to welcome you to only our fourth in-person event in 3 years, and the last lecture of the season. Our programme was, of course, affected by the pandemic, but we went online, and so the lectures that we had online are on our archive. So we have lots of video of lectures across the last 2 years, as well as an extensive audio archive of lectures before then. And this evening's lecture, as the other ones in this semester's programme, will also be on YouTube after the event. The Institute for Government, founded in 2008, is probably our leading institution for studying government, for improving government, if it's thought that improvement in government is possible or necessary. And in the 9 years or so that Catherine Haddon has been a fellow there, a period of calm, sober government in this country. Nevertheless, she's found herself a ubiquitous media commentator, radio, television, newspapers, explaining what's going on, and the responsibilities of explaining what's going on in a particularly febrile and polarised public debate has been no easy task, but she's done it with great effectiveness, and that was why I was very keen to have a lecture at the end of the programme, which was to mark the Platinum Jubilee, because in all of the uncertainty and the tumult of the last 10 years or so, there's been one continuity at least, and that is the Monarch. But that continuity will not last forever, and much discussion has already started to take place about the nature of the institution and its relationship to a democratic society. And so that's why I thought Catherine would be the ideal speaker today for this lecture, and I hope you'll join me in welcoming her to the podium.
Thank you, Martin. That was a very nice. Normally people just read out my bio from the IFG website, and I keep thinking to myself, I must go back and change that. So very nice introduction. Thank you, Newcastle University and the Insights team for having me, and thank you all for being here. I know it's a lovely day outside and the end of term, but it's a real pleasure to be able to share my thoughts on this subject with you, and also to test them out a little bit. I'm hoping to get some good questions, a bit of debate, so that you can help me refine my thinking, because this is, I think, a debate that we increasingly need to have in the country about the UK Constitution and about the role of the monarchy in it. You know, it will be useful to get some reflections to help me think about how I can contribute to that. Now, I want to start off with a quote about the UK Constitution. It's one that's been cited many times. Some of you may be familiar with it, and it was one that just seems to me to be the best starting point for this lecture. The British Constitution has always been puzzling and always will be. Now, some of you may feel this completely sums up the UK Constitution. Some may feel it lacks a little bit of depth, but it's a very apt starting point. The words were uttered in 1992 at Queen Mary University, perhaps intended as a throwaway remark. Unfortunately, spoken in the hearing of my old professor Peter Hennessy, who, the journalist that he is, wrote it down and immortalised it in his own works on the Constitution. The person who summed up the Constitution thus, Her Majesty the Queen. Like I say, hopefully not all that she thinks of it, and given the many years of her reign, hopefully also not entirely as puzzling to her as all of that. But what I like about it, the quote, is that it shows that she's not just a figurehead in the Constitution, not just a cipher. She's also an active player in it, and perhaps someone who sometimes ponders its stranger elements just as much as the rest of us. Now, talking about the Queen, obviously, in her Jubilee year, it feels like quite a momentous topic for a lecture. Largely for me, because it puts me at risk of presenting myself as a complete expert on all aspects of the monarchy and of our royal family in particular, and we were discussing this outside a minute ago. I'm afraid I have no great interest in all the Harry and Meghan debates. I was taught by someone who is, but I'm not myself an expert on the Commonwealth. And even though the Privy Council Secretariat used to work in the same offices as the IFG, I am as baffled as many people by some of the finer points of ceremony and royal etiquette. I'm not saying this is sort of imposter syndrome, you know, what one says when one comes to do a talk to a room full of people. but because it's really important for you understanding where I'm coming to with this. What fascinates me and has done ever since I first encountered what's the Cabinet Secretary, I know you had him here not so long ago, precedent book in the National Archives, is the role that the monarch plays in particular in the formation and functioning of our executive. Everything from how governments are appointed, what happens when an election doesn't make that clear, how conventions operate, and particularly the ones that involve the monarch. But also how the hidden guardians of our constitution operate. And I'm talking particularly about those civil servants whose job it is to deeply immerse themselves in the often prosaic but sometimes acutely dramatic role of explaining the constitution to ministers. I'll come back to that. As an aside, the precedent book is amazing if you ever get to look at it. It unfortunately no longer exists. I don't know if Simon has managed to resurrect it. But it's basically a file where past cabinet secretaries compiled all the memos and notes that explain why various things were decided upon constitutionally. And before the cabinet manual, it was the closest thing that we had to a written constitution on some of these sort of deeper and more elusive parts of our constitution. Obviously, with the monarchy, and particularly the fact that the archive rules mean that it takes 100 years for papers about the monarch to come out, you get even less of that material. So there are aspects of it that touch upon the role of the monarchy, but a lot of what we know about it actually comes from eyewitnesses, principles, or just people thinking about the sort of broader context of how the monarchy, operates. But I think that the role of the monarchy can't be left out of thinking about effective government, which is the job that the Institute does. It pervades many aspects of our government and our state. Civil servants are servants of the Crown. The real estate of our government is the Crown estate. Parliament consists of three core elements: the Commons, the Lords, and the Crown in Parliament. And more specifically, the thing that I focus mostly on, the executive, it is effectively the Crown. Ministers exercise power through the royal prerogative, as well as statutes and powers in their own right. The Cabinet is a committee of the Privy Council, and although for much of the day-to-day activity of governments, this might seem like mere process or formality, as we've seen, and I'm going to talk about, in some of the difficult periods of recent years, there are times when that fact really matters. So, although you've come to hear a talk about the Queen, and we're talking about her Jubilee, what I'm really focused on is the Constitution, because many of the constitutional controversies and debates of recent years either relate to the monarch or they open up problems that may affect how the monarch's role in the Constitution evolves in the future, including some of the potential areas of controversy that only a few years ago seemed, to be highly unrealistic things that would happen in this country, but now seem all too possible. So we've got all sorts of questions that have come up. How do conventions and principles interact with statute or statutory bodies in a constitution? Beyond just the codify or not debate, how does a living constitution get interpreted on a daily basis? And how does it guide the actions of those who are in power? How far do you have to specify constitutionally what is and is not allowed if new situations arise? How do you interpret old precedents and principles for a new situation? And what role does institutional memory, of which obviously the Queen brings plenty, play in the operation of our Constitution? And most fundamental, and this is going to be a big theme that I want to talk about, who guards our Constitution? Who has authority? Not just what's written down or in statute, but who do people feel is an authority to act as a guardian for the way in which our system of government operates? So, I also want to think about the sort of day-to-day of how this operates in the Constitution, because a lot of what we talk about is ministers exercising their powers, Parliament exercising its legislative and scrutiny roles and so forth. But as they're doing all of that, they're advised continually by the people who work there, whether they're parliamentary clerks, civil or public servants. Various documents guide them: statutes, common law judgments, standing orders in Erskine May in the case of Parliament, and then things published recently by the government, including the Ministerial Code and the Cabinet Manual. There's lots of history as well. This isn't just an issue of public law. There's archive material that I've talked about, and there's, of course, many academic books, but it's still a living, breathing thing. Ministers may ask, can I do this? Civil servants and government lawyers may trawl through to find ways to achieve what government wants to do, and sometimes they will have to say, no, Minister. And it's worth remembering, and we don't talk about this enough, that the Queen, or rather the Palace, plays a role in this. Peter Hennessy talks about the golden triangle, the three roles of the Cabinet Secretary, Principal Private Secretary, and the Private Secretary to the Queen. It's a triumvirate of the most senior officials who keep Number 10 and the Palace informed and at times works together to resolve various complex constitutional problems. But the reality is it's much more complicated than that. Officials in the Cabinet Office and elsewhere in government are keeping regular touch with the Palace on sort of day-to-day prosaic issues, or, you know, the big moments of state visits, opening of Parliament, requests for a general election, royal assent for legislation, and like I say, the more general day-to-day stuff. And this is really important because when we're thinking about the role of the monarchy in the Constitution, we're not just, as I say, talking about the formal institutional role, but we're also thinking about the human element to it. How do people actually think about it on a day-to-day basis? Not just what do we say in the academic books about what the powers are and how can they be used, but actually how do people then use that to advise ministers and to talk about how to resolve issues as they go. So, to talk about some of the key issues around the role of the monarchy in the Constitution, the big one for me is reserved powers. These are what some people call personal constitution prerogatives. They're the sort of residual powers of the Crown, but they are the ones that, in particular, the Queen is expected to operate separately from ministers. Some of them are, you know, ones where there is a great deal of debate about how much discretion she actually has. Things like the dissolution of Parliament, which has recently been returned to a royal prerogative. Obviously, prorogation of Parliament, which was a big controversy a few years ago, but also things like the appointment of prime ministers. In some of these, she's still advised by ministers, but there is, like I say, a debate about how much she can and actually deviate from that. And some of these powers, particularly the prorogation and I think in future dissolution of Parliament, have been very much in our minds in recent years and increasingly called into controversy. Before, though, I come to those involving the Queen, I think it's useful to talk more generally about the role of conventions in our Constitution, because a lot of these govern many aspects of how the monarch plays a role, but also the way in which conventions have been degraded in recent years, I think opens up questions for us about how the monarchy's role will continue in the future. Constitutional conventions, if you don't know, they're the customs, practices, they're sometimes rules, sometimes principles of our Constitution. Along with Acts of Parliament, key court judgments, they form a vital part of it. The Cabinet Manual describes them as rules of constitutional practice that are regarded as binding in operation, but not in law. But some are, as we're discovering, or perhaps rediscovering, more binding than others. It's actually only a convention that the government resign if another party wins a majority at a general election, but at the moment we couldn't conceive that a government would not do that. It's a convention that ministers are individually and collectively accountable to Parliament, and, as much discussed recently, it's also a convention that a minister resign if they knowingly mislead Parliament. Many conventions govern the role of the monarch and the relationship to the executive, the weekly audience, not bringing the Queen into political controversy, and also some of the rules about how her reserved powers function. She appoints a Prime Minister on the basis that they are likely to command the confidence of the Commons, but again, this is based on convention. The problem is about the enforcement of these conventions. Breaches don't have automatic penalties. Parliament might take steps, particularly on those conventions which speak directly to its role. We've obviously seen a contempt of Parliament investigation that will be undertaken possibly sooner now, given that the Sue Gray report seems to be coming out next week and the Met Police have finished their investigation. But our constitutional history is littered with lots of examples about the different ways in which they've been addressed when breaches have occurred. Sometimes a sense of propriety leads to contrition or an action or resignation. Sometimes it comes down to the internal dynamics of political parties. Sometimes it's the media and political outcry that has the impact of enforcing a convention and pushing it back into place. Ivor Jennings, who talks about conventions quite a lot, says that there's 3 elements that are necessary for one. Number 1, that there were precedents. Number 2, the actors involved must believe themselves to be bound by a rule. And number 3, that there must be good reasons for the rule. What I found fascinating in recent years is that 1 and 3 have so often been in tension with the second one. There's plenty of precedents for most of the ones that I've touched upon today, most of the conventions that are sort of crucial to our constitution, though obviously new precedents have also been set in recent years. And there's certainly still some very good reasons for some of them. But if the actors involved don't believe themselves bound, what can you do? So we're now facing a position where I get asked repeatedly by the media and by others, yes, I know it's a constitutional convention, but do they actually have to obey it? And that's always followed up by the question, but can actually anyone make them? And this undermining of constitutional conventions, which has been a feature of the last few years, the can of worms of can anyone make me? Oh, sorry, I've jumped ahead. Do a Boris Johnson and say, forgive me, forgive me. We saw more and more pushing of the limits of constitutional conventions. To turn, unfortunately, to Brexit, my apologies. I think that some of what happened in the summer and autumn of 2019 was hot air. First, with the leadership campaign that got Boris Johnson to the premiership, and then the new number 10 operation under him. They were briefing out more and more things that they might be willing to do to get Brexit done. And a lot of that was to do with the relationship with the media. And as some of us realised at the time, and many involved have admitted since, there was an election undercurrent to all of this. The number 10 team knew that they had to show they had tried everything to get Brexit done. And they very successfully posited that against those who were seeking to stop or change what the Johnson government were trying to do. But in both what they did and in talking about the willingness to push at those conventions, they've damaged the perception of what constitutional conventions are, and indeed what that means for our constitution beyond what is actually in statute. Now, I don't think that the controversy started then. In a sense, it's, constitutional controversies have always been with us. You can go back to the 19th century, find tons of them. Even in my own experience, there's been lots of debate about, aspects of constitutional conventions. I remember back at the 2010 election, where the Liberal Democrats were very unhappy that Gordon Brown had resigned before the coalition negotiations had concluded. But him doing so was actually constitutionally proper. Once it became clear that he couldn't form a government, it was only David Cameron, whether he had a coalition in place or not, who was most likely to be able to command confidence. So it was right that Gordon Brown resigned and Cameron took office, even though the coalition negotiations hadn't finished. But I think that also shows that sometimes it's the desire for new conventions that pushes and pulls at our constitution as much as the fraying of old ones. And similarly, even before the Johnson government, during the 2017-9 Parliament, lots of parliamentary conventions in particular seem to become fair game for the battle between Parliament and the government in terms of trying to navigate Brexit, come to a solution, or at least stop the ones that they didn't like. But the parliamentary and political battles of recent years have created a situation where constitutional norms seem to have become fair game. And I think the prorogation crisis of 2019 was the culmination of that. On the 28th of August, on the advice of the Prime Minister, the Queen ordered Parliament to be prorogued from between 9th and the 12th of September until the 14th of October. It was going to be a 5-week suspension of Parliament, and that meant that Parliament would return just 17 days before the scheduled departure of the UK from the EU. I'm sure you all remember it was very controversial. Now, the government argued that this was perfectly normal, that it was covering the conference season, where it's usually a recess. But in this case, they needed to have a Queen's speech, so they needed a new parliamentary session to start and reset the business of Parliament. There's an element of truth to that, but the length of the prorogation and the context of what was going on undermined those arguments. It would have been entirely possible to achieve both of those aims with a much shorter prorogation as eventually occurred. Now, as you remember, the Supreme Court eventually ruled that the advice on the prorogation was unlawful, and therefore the prorogation was nullified. It didn't happen. There's a lot, obviously, that we can debate about what that precedent may have set for the role of the courts. I'll leave that to others. But what it did was also put flesh on the bones of the question about whether the Queen can act in her reserved powers to refuse, in that case, a prorogation, and whether or not it undermined other conventions, such as not politicising her role. On the latter, I think it's pretty clear it did. It put her in an incredibly awkward position purely because of the controversy and because of the questions it's posed about the efficacy of her reserved powers. So that brings me to the fundamental question of those reserved powers. Can the Queen actually exercise them? She didn't, of course, refuse the prorogation, but I think the case still says a lot about whether or not she could. In large part, I do concur with those that say that she still can act in extremis. And unlike some, I think the prorogation only reinforces that, because it's worth remembering how awkward a decision that would have been. The 5 weeks was long enough for a suspension for the court to consider it beyond the pale. But it wasn't as egregious as, say, proroguing for the whole of the period up to 31st of October, which is what, certainly during the summer, we were getting briefings coming out of government saying that they might do. If that had happened, and I think she hadn't acted, then yes, I think you could argue that the reserved powers have no function whatsoever. But I think if she had refused it at that point, and this is why it was such an awkward position, she would have been accused of a political act by refusing it. So she was damned either way. And it's a stark lesson, therefore, of the dangers of dragging the Queen into such controversy. So just because she didn't refuse, the fact that it was being considered within the palace whether or not she could suggests a possibility that she might in future, if there is, again, an extreme abuse of one of these powers over which she has some oversight. Now, the reverse argument that she's got no discretion, that she is basically a figurehead, and that these reserved powers do not really exist as a kind of check in our system, I think that's really important, because most commentators, I think pretty much all commentators agree that she is constrained in acting. She definitely is. And this is in large part, again, down to convention. As we saw with prorogation, the problems of the Queen becoming embroiled in political controversy is an impediment to using those powers. She's kind of got her hands tied. If she acts, she crosses the line. That, obviously, is a reason why some people argue that the role doesn't work. We'll come back to that. But the other reason I would argue that there is some scope for the exercise of those powers is, again, going back to recent stuff. The Fixed Term Parliaments Act, another favourite that I have been looking at in recent years, is now part of history. It's been replaced by, again, a return to a prerogative power, where the Prime Minister is able to request a dissolution and the Queen decides whether or not to grant it. But alongside putting out that new act, the government released dissolution principles, and these harken back to a very famous letter written to the Times in 1950 by the then Queen's private secretary, Alan Lascelles, which set out principles where she could refuse a dissolution of Parliament in a general election. Those were largely around if the Parliament was already vital and existed and didn't need to be got rid of, if there was if the national economy meant that it was a bad time for an election, or if there was an alternative government that was in place that could take over. We've got similar ones, again, published now, but I think the fact that the government and the palace have published them is effectively confirming that they think she still has a role. Now, of course, as many people debated during the passage of that bill, having a theoretical role isn't the same as being able to apply it. There's also, quite a general consensus that the circumstances, again, in which the Queen could refuse a dissolution in a general election would have to be pretty extreme. As an aside, that was debated recently where a lot of journalists started asking if Keir Starmer has to resign and there is a leadership contest in the Labour Party, can anyone stop the Prime Minister from requesting a dissolution. And a lot of my Twitter feed ended up being full of a very long thread of various constitutional commentators arguing against each other as to whether or not she could or not. But they were arguing the wrong thing, because there isn't anything in the dissolution principles that say that, you know, one could be refused in those circumstances. There's no alternative government in place, and there's nothing that stops the Labour Party campaigning for a general election. So, you know, it doesn't matter. The one convention that does actually matter for that is the don't drag the Queen into political controversy, because, again, it would be seen as very controversial. So they were looking at the wrong convention, but that's an aside. But again, this brings us back to this general feeling that, you know, there is some scope, but it would have to be pretty extreme for the Queen to refuse a dissolution. So all of this leads to the question about whether or not people now need more precision to understand when she can and can't act. The academic Anne Twomey calls these powers the veiled sceptre. Now, she argues that looking at how such powers have been used, not used, or have brought controversy in various different systems, that strict rules and categorisation have not proved helpful. This kind of reinforces the idea that flexibility in a constitution is valuable. Instead, she argues that they need to be based on fundamental principles, including responsible government, representative government, and the rule of law. Again, big themes that have been debated a lot recently. Likewise, during the passing of the Dissolution of Parliament Elections Bill, some people argued that it was the threat of the Queen's ability to refuse a dissolution that was important, not the expectation that she actually use it. So it's not even that you think that she will do it, it just exists there as a threat. I've got some sympathy for this argument, largely because I've so many times been called by journalists to answer what someone who also ends up doing this recently told me they've called the die-hard scenarios, as in the film. One I had in 2015 was, what if there is a hung parliament, the Prime Minister got hit by a bus and nuclear war broke out? It's a great one. Now, of course, you can't foresee every scenario, but frankly, I must say, even with that scenario, there are various rules and principles, so I could give an answer, which led to the journalist then thinking up some more sort of connotations to try and throw me off further. So obviously, yeah, you can't plan for every particular scenario, so you do have to have kind of principles and, like I say, precedents and other ways of interpreting how the Constitution will work, certainly with the Constitution that we've got. But where I struggle with all of this is that when doubt creeps in, as it has in recent years over all of this, whether that deterrence effect of the Constitutional Conventions really holds up, and whether or not this ambiguity is good enough for the public anymore, and particularly around the role of conventions, but also around the role of the Queen. Because we don't have very easy solutions, even when the principles and precedents exist. And again, we faced another such scenario in spring 2020 when the Prime Minister ended up in intensive care. We've got no specific rules for succession of Prime Ministers other than a party leadership contest. And in that case, the guiding principle, which was that the politicians in the party with a majority able to command confidence, in that case the Conservative Party, would have to resolve it if the worst had occurred. That effectively means that the Cabinet would have had to advise the Queen on a successor and then gone on to run a leadership contest in the Conservative Party. Whether or not they could have navigated that politically is a huge open question, and I think another big gaping hole in our Constitution. So it is understandable when you've got scenarios like this that aren't just theoretical, but actually have been coming up as potential issues in recent years, that the public wants some certainty. They want to know who's in charge. They want to know how things will be sorted out, and they want to know whether the rules seem to them to be fair. What people want is a constitutional guardian. And the thing is, when the Queen gets brought into it, it usually becomes about that. It's about whether or not she can intervene. And this isn't just a problem, though, facing the monarch in our Constitution. I think it goes wider. And again, talking about recent stuff, Partygate's been another example. At the height of the drama back in January and February, a lot of the focus was on who would hold the Prime Minister accountable for this. A lot of anger in the public and people feeling like it wasn't being resolved. When I went on media, I had to say, ultimately, it's a decision for Conservative MPs, and that leads to frustration. Because Partygate, in a sense, or at least that aspect of it, has been a test between two different perspectives. One is the view that it should be Parliament, ultimately, who decide on the future of a Prime Minister, because parliamentary sovereignty trumps everything in our Constitution. That means that the decision automatically becomes political. It becomes about whether or not the Conservative Party want to keep him. The other view, of course, is that it shouldn't become political in that way, that there should be a higher guiding principle, and that therefore needs to be some other ultimate judge for such matters. And when people are searching around for who that judge should be, some people look to the courts, obviously codification gets brought into it, and sometimes people talk about the Queen, and I get asked whether or not the Queen can sack the Prime Minister. This desire for constitutional guardians, for authorities who can rule on any disputes, I think is something we don't debate enough. And I think it's entirely natural human feeling that we have about wanting some certainty. And I think it's particularly illuminating when it comes to the question of the monarchy and the Constitution, not least because it then becomes not just about whether or not she can intervene, but also about why she is trusted to be such an authority in the Constitution, and the degree to which that is also bound up in her own persona, not just in the institution of the monarchy. So, to talk briefly about the apolitical nature of the Queen. Now, Vernon Bogdanor, another great constitutional authority, wrote that the benefits, if you will, of a monarch is that they don't have the political history that any elected head of state would have. I'm going to leave that one hanging for others to dispute and debate. But the reason I raise it is the point he's making is that the persona around the Queen in particular has become quite central to her role in the Constitution. Bogdanor said that if the sovereign carries out the constitutional functions in an impartial way, he or she is in a better position to represent the nation as a whole and to be a representative who everyone can accept. For the purposes of what I've been discussing today, particularly debates around the reserve powers, that impartiality, or more accurately, its apolitical character, seems to be pretty crucial. We've ended up evolving into a position where our Constitution and the role of the Queen is pretty based on the way in which she herself has personified the role. And it's something that the Queen in particular seems very conscious of and has taken great effort to cultivate over the course of her reign. It gets cited every time she's out and about and says something that even touches on a political matter, when she said to a member of the public, for instance, that she hoped the Scottish independence voters would think carefully about the future. There were times, looking back, that she did, perhaps blur the lines of that, and the one that's often cited is the 1963 change of Conservative leader, from Harold Macmillan to Alex Douglas Hume, where senior Conservatives felt cut out of the process and that it was stitched up by those who talked to the Queen and advised her to make that appointment. Why is this important? It is important because, as Martin said, the monarchy is going to be changing at some point in the near future. And the question often gets asked, certainly to me when the media call up, about whether Charles as king will be able to be seen as apolitical as his mother. Mostly, they're asking about his views on various issues, the Black Spider letters, things that are already known about him. But I think it also goes to the question about the difference between having views on issues and how it's applied to the role of being monarch. The Queen has the right to be consulted, encouraged and warned. Now, we don't know how she actually operates any of that. She has, as I say, the weekly audience with the Prime Minister. It may be that actually, and she reads the papers of the government, she gets a red box like ministers do. Perhaps she's actually played quite a firm role in various moments of sort of political drama. Maybe she has made her views clear, but it never reaches the light of day. So it's really more about perception rather than whether or not they do have views. And the point I would like to make is that maintaining this balance relies on what I'm calling the good Queen theory. So like Peter Hennessy's good chap theory, if you've ever heard of that, the idea that historic aspects of our Constitution, its reliance on convention, depend on continued compliance and ultimately good behaviour, so too does the sovereign's role in the Constitution frequently depend on trust in her personal approach. She may not use the powers, they may only be a threat, but the perception of the monarch having an apolitical role in our constitution is fundamental to their existence. So whether this balancing act can be maintained after the succession is a problem that both Charles and the government will need to consider. Charles will undoubtedly want to make changes anyway. I'm sure there'll be some modernisation, whatever that looks like, perhaps slimming down the size of the monarchy and how public funds support it. We've already seen him deliver a state opening of Parliament, a speech from the throne. I'm sure there'll be lots of thinking about how he's going to convey himself as both continuity and a refresh, a change. But how he cultivates his persona as king and whether that differs from that of his mother is an open question. If he does seek to follow in her footsteps, how will he seek to demonstrate his impartiality? Or will he try and change the role and try and show that there is the possibility for a monarchy to have for a monarch to have views on various things? The question is whether some of the aspects of how these reserve powers operate or don't will change with a new monarch. How important is trust in the judgment, and how much does that reside in the idea of a monarch or in the particular personality that Queen Elizabeth has brought to it? And it's not a challenge that Charles will face alone. It goes to the heart of how conventions operate and the importance of institutional memory, not just in knowing that they exist or understanding the finer details of our constitution. It's also about why these aspects of our constitution, particularly those on which so much else rests, matter. So is "don't embarrass the king" going to be as great a deterrent as "don't embarrass the Queen"? I think it's a fascinating question. That, in large part, is going to be down to the politicians. It means that that maxim isn't just about not putting a national figure who's, pretty well beloved, held in high esteem, an elderly woman in a difficult position, which is a lot of what we talk about it at the moment. It's also about appreciating the constitutional risks of putting the monarch into highly political positions. But given the experience of recent years, it's no longer inconceivable to us that there could be a situation where a hung parliament leads to disputes about who could be prime minister. It's no longer inconceivable that a situation might arise where a prime minister loses the leadership of their party and therefore the confidence of Parliament, but refuses to stand down and instead seeks to go to the country in a general election. All of these situations can be resolved without dragging the monarchy into a major political row, but only if there is adherence to basic constitutional principles. And as we've seen, that's not as certain as it once might have been, maybe even 10 years ago. So, what do we do about this? Now, you could argue that obviously everything that I've talked about today leads to the argument of codification, and certainly a lot of people do argue that, particularly in my replies on Twitter. I'm agnostic on the principle in general. I think if the public wanted it, it should happen. But I do think, although I think we're likely to have greater, more piecemeal codification, more and more things put on the statute, and some for good reasons, there are some problems with codification. One of them is that some people arguing for it are conflating, the difference between wanting codification and just wanting more certainty on the Constitution. That speaks to the problem of how we learn about the Constitution, how we talk about it, institutional memory. It's totally understandable. At other times, I see people arguing for codification when actually they want a change to the Constitution, also a perfectly valid thing to want, but it's a different discussion. What I'm most wary about is pushing towards it when we've still got so many constitutional questions that are very uncertain, whether that's how our executive operates compared to Parliament, whether it has too many powers compared to Parliament, whether it's undermining the role of Parliament, whether it's the future of the Union, whether it's English devolution, the rights of citizens, the powers of the courts, or even the balance between our various institutions. These are all massive constitutional questions that at the moment seem a bit in flux, that we don't have agreement on them as a country. So I just think we can't codify unless we know what we are codifying. And I think we're still a long way from that. So I do think we need national conversation about the content of our constitution, before we then get to the question about how we then enforce it and who enforces it. And that's one reason why the Institute for Government and the Bennett Institute in Cambridge are looking into many of these questions and hoping to bring some light to some of them. But there are other things that can or might happen. Optimistically, perhaps we've reached a low point. Maybe in future we might see some reassertion of the importance of constitutional norms and principles. I think don't embarrass the Queen rule. I think that's going to be considered a bit more, at least for the next few years. But on the question of the need to retain conventions and the way in which they're being pushed and pulled around, it's a bit harder to see that, that has been resolved, that it can't get worse from where we are at the moment. I think better awareness, more reassertion by those in Parliament, people in Cabinet, by, our political leaders, that these things matter can help. And I think it is also valuable that all that's happened in recent years has increased knowledge of the Constitution and concerns about the consequences of being too cavalier with different parts of them. So perhaps, again, the optimists can think that by going through all of this drama, we've been reaffirming the importance of principles at the heart of our democracy. But mostly, I think we need to explain more why aspects of the Constitution matter, or indeed explore whether they don't, or they no longer achieve what they seemingly existed to address. And this isn't just asserting high-level principles of the Constitution, reciting the long history of particular parts of it and saying, therefore, you can't get rid of them because they've existed since 18 whatever. Because the Constitution is often a dry, dusty subject, but it exists to make things work. It exists to protect institutions and people, to bring us a shared sense of rules. And it also exists to make government work, to make it do what it's supposed to be doing for the public. That's why when I at the Institute and my colleagues are talking about aspects of the Constitution, what we want to do is say why it actually has an importance to what you're trying to do in government. When I'm talking about the ministerial code, we're not just saying it must be obeyed just because it must. We're talking about how it can help, how it can even protect ministers if they follow it. As far as the monarchy goes, its fundamental role at the heart of our Constitution doesn't currently seem a major topic for debate, but understanding the powers of the monarch, how they operate, and the role of conventions more generally does seem to be an area that needs more exploration. And with the succession, we will see a change in the monarchy sometime in the coming years, and this may lead to some debate about what is good and what can be changed in our monarchy, and how it works in our Constitution. I don't think we should be afraid of that. For a long time, the Constitution, and particularly the role of the monarchy, was treated with great deference. And there's a lot of secrecy about it. You couldn't talk about it. It happens off in dark corners. Peter Hennessy called it the hidden wiring. I don't think it should be hidden. I think we should have better understanding of it. We should teach it more, and we should let people feel able to engage with it more. If what any of these controversies have taught us is that it's better to be on the front foot discussing what works and what does not, rather than allow things slide to a point at which crisis occurs. And it is healthy for citizens to feel like they understand and are reassured about their Constitution, because the Constitution does ultimately belong to us. So to go back to that original quote, it's puzzling and it always should be, it shouldn't. And we should seek to find ways to make sure that it isn't puzzling for generations in the future.